Good morning to everyone. We'll call the 8:15 review calendar. That's, I'm not sure who else here, so we'll go by docket number. Garrett Coleman in the courtroom. Garrett Coleman does not answer. Marvin Dart. Mr. Dart, good morning. How are you? So far, so good. Just hoping for cooler weather. Mr. Dart, this case goes back a little bit. And once again, the treatment is an issue. And the latest thing we have filed August 2nd is not in compliance. What?
Yeah, the last month I lost my job because of all these court dates from my pastor coming up, and everything's coming up, and I lost my job. And then we lost a caregiver for a handicapped daughter, so I'm having to stay home and take care of her while we're waiting for work. And then, so I'm in contact with treatment. I went last night. I'm gonna go today. So since she's on, and I understand what's going on.
Well, you know, that's one of the things about the legal system. Sometimes we beat people over the head with much more help and treatment than they can afford or have time for, et cetera, et cetera. That's the economic realities being what they are. How about if we set the matter out about 6 weeks and just see how you're doing then?
Okay.
The important thing is, and I want to commend you on this, is I don't see any indication of any new violations. It looks like life is going well otherwise.
Yeah.
City, have any objection to simply setting the matter out about 6 weeks?
No objection. The city would just like to see that.
As long as you're in touch and working on that, I can't ask for anything more than that. Resetting it for September 28th, 8:15. I'll sign an order resetting that. The order on today's hearing, Mr. Dart, you can get at the window outside. Yeah, it sounds like things are a little rough financially and otherwise right now, but and the beyond hot weather probably isn't helping very much either. But I'm going to wish you the best of luck and do the best you can. Just do the best you can.
Thank you.
Mr. Dart, thank you for appearing. Thank you for your patience. You take care and have a good day. Erica Fleming. Good morning, ma'am. How are you? Well, it says the victim impact panel, that needs to be done. And also it sounds like that new violation with the county. What is that violation?
The new violation is driving on a
Suspended license? Anything alcohol related?
No.
How about the victim impact panel? Is that proof that you have done it, or?
Yeah.
Okay, sure. If you show that to Mr. Redfield, the prosecutor, and we would like to have that on file or make a copy of it at least. Perfect. That said, you need this back. I want to.
This is not gonna happen again. I don't need it, but if that suffices the court, then okay.
Now, the new violations are DWS third and the ignition interlock. That's a requirement that's fairly recent of vintage, this ignition interlock one. You've got to do it for a period of time before they'll release that, and et cetera, et cetera. But you don't have any new offenses that are alcohol related, and that's what concerns me. So I'm gonna give you a pass on that. Just wish you the best of luck at dealing with it. Does it have pretrial status?
Yes, I go back. I go to Olympia. The 18th of September.
Oh.
And I thought if I waited out the time period, I didn't have to get it. I did not know it was like.
If you have a public defender, there in Olympia?
There's revealing.
There, I know that's an issue maybe, but you need to ask your public defender about that gets a little complicated, the ignition interlock requirements. I'm going to wish you the best of luck. I'm going to find you in compliance and hope that your other case goes well.
Thank you.
You take care and have a good day. Any questions at all?
No, sir,
I'm open, so no, that's
I guess
if
all
there's
you
any
gotta
problem,
do
there
is-
might be, we still have jurisdiction to impose suspended jail time, et cetera, et cetera. But that's nothing's gonna happen. My concern is alcohol related offenses. And as long as there's not that, I'm not real concerned about anything else. I'm gonna wish you the best of luck. You take care of yourself and keep in mind, driving, it's, these things, they impair your ability with insurance and compliance with this, that, and the other, but time goes by, all that drops off your record and, be clear sailing. Okay?
Yes.
Ms. Fleming, good luck to you. You take care of yourself and, unless something unusual comes up, you won't be hearing from, you need this or
Can I take it to get a copy?
you certainly can, certainly can. You take that to the front, come on up and ask, that a copy be made of that and then I thank you. You take care of yourself. The other strike, I'm going to strike the hearing and find you in compliance. Thank you, ma'am. Eliana Hazlet Olszewski does not reply. How about Tim Higgins? Mr. Higgins, how are you? So far, the day's gone well. The docket entry I have says you've been discharged from treatment. That's never good.
Email you guys got this morning?
Received this morning, date of treatment plan, hey.
And then
I opened the file and here it is.
Yeah. Then
This is treatment October, November, then you were discharged. Reason for discharge, clients whereabouts unknown, lost the contact.
that's the. And then I'm with friendship version now. I can give you guys a copy of that if it's like. I don't know.
Come again?
And then I'll also be starting back with Seymour on the 20th of November.
The friendship diversion program is an alcohol treatment.
Yeah, it's through probation. It's just something else that I'm doing.
But we don't have any proof of that,
For what?
that you're in compliance with treatment. You were discharged from treatment,
Yeah, the discharge was the assessment that you guys have up there. It has no further treatment plan. But I will be starting back with them on the 20th of November. Because the earliest date they get.
Timothy Higgins is not engaged in treatment to date. Several attempts to engage the services has failed. Well, apparently the evaluation didn't require or mandate a treatment program. If you started with that, we're in compliance in October, November, then discharged.
Yeah, through Providence, and I switched over to these guys.
To who? Who did you switch over to?
Seymour.
Seymour is the one that discharged you. That's where I have the discharge from.
I don't know anything about a discharge. They had no further treatment plan when I went and did the assessment.
Yeah, that's like that. Sounds like you started with Providence, didn't like what they said, went to a CMAR, they recommended an outpatient treatment program. You started that in October, November. Hey, could you speak up a little bit?
Providence was one that had recommended the outpatient.
Okay, and
That I was with them for a
And
while.
so what you're telling me is you did some treatment shopping and got an evaluation and said, nah, you don't need
Well,
it.
yeah, it was just too far going to Lacey every other day, so I could just go to Yelm instead.
What are you doing now by way of treatment?
I'm doing friendship of everything, it's just drug tests.
That's not treatment.
By the courthouse up there by the Superior Court. Getting back to see more.
Well, the difficulty is I have no, I don't have any proof of that. I hear you say friendship diversion. But I don't have that. Could you give Mr. Hatfield a copy of that?
Yeah. I can get a copy.
Pardon?
Yeah, I can get a copy.
Higgins, this is a substance abuse monitoring program. This simply monitors compliance with any order that you not consume. This isn't treatment.
Yeah, it's just something that the probation had ordered. It's released, like, the earliest they could give me.
What, you know, what have you got going in Superior Court?
What's that?
What do you have going? What court is?
The same case, because they had split the reckless and the domestic.
When do you plan on being back in TV?
November was the earliest that they could get me.
Higgins, a judgment and sentence suspends 347 days. Your case has been in warrant status any one of a number of times. Eventually, the case gets to the point where we simply impose the suspended jail time and give up and close the case. You're planning on being back in treatment in November.
Yeah.
City, have any,
I don't know if you want to set
input?
another date for after the 20th. Give you guys the new assessment, feedback.
We would like a copy of the assessment, because that kind of tells us, you know, where we're headed and where we're supposed to be heading. We don't have that. We have the, some original material from,
Yeah, that's
Providence.
That's my whole assessment from Seymour from December, and then the Providence stuff, yeah.
problem is people in the system, judges, prosecutors, they see one evaluation and then you see a jump to another. That's the first thing that comes to mind is, you know, treatment shocking, that someone's just looking for a way.
More like medical shocking, I guess.
The, this is dated August 8th.
2024.
Case manager, is that John Kaya?
Yeah, that's who I'm working with up there. And my probation standard bearer.
Somewhere that's. When I see a document stated, a year from now, I kind of look at it askance. What,
Does it have the wrong year?
pardon?
Does it have the wrong year?
It's dated August 8th, 2024. This is 2023.
Okay.
It's
Yeah, it is. It's got the wrong year.
what I'd like to do is I'm going to just continue this to the next available court date. That's August 31st. What I want to do is hear something directly from Friendship first. There's a reason why treatment agencies want police reports, records, et cetera, to come from the court or the prosecutor. Need this back?
Yeah.
You can get something, I'd like to, given the history here, I'd like to have more assurance that something has happened. You know, like you may have heard me indicate a little bit ago that, yeah, that's hoops to jump through, and, you know, the goal of them is to do everything that we possibly can to make sure you don't have to come in on a new offense. And so far so good, it looks like. But yeah, the sooner you jump on this, the sooner it goes away. Sign an order to that effect. Mr. Higgins, yeah, I'm just not convinced that jail does anything for anybody other than ensure public safety. I hate to go to that result, and that is the absolute last result as far as I'm concerned. But I'm going to wish you the best of luck. I want to see you again in a couple of weeks, and I would like to hear something directly from Friendship about your involvement with them. Take care. Thanks for your help. See you in a couple. Get a copy of today's order at the window. Derek Mead. Mr. Mead, good morning. Mead, you're on a stipulated order of continuance with conditions. It looks like I have a recommendation here from the probation clerk that we simply recommend the SOC and impose a sentence and go on from there. The problem is treatment. Yeah, the premise of the continuance is was that you get an evaluation, comply with any treatment recommendations, and apparently that is just simply not happening.
Right.
There's actually been no complaints. You have new violations, owe money, et cetera, nothing is happening.
I was gonna make another payment today.
Pardon?
I was gonna make another payment today as well.
I'm way more interested in the other parts, the treatment.
I called them, let them know that I was working full time. Like, honestly, I just couldn't take a day off, trying to tell them. And,
Yeah, well, yeah, that's they do terminate treatment if what they try to do is keep people in compliance, and if they fall out of compliance, they terminate you. They make a reasonable effort to get you back into, but if that doesn't work, they give up. That was one of the premises of the agreement. If the city's if city's moving to revoke that, we can set a revocation hearing. Cities moving to revoke, the charges are DUI, DUI second, there's mandatory jail time on the DUI. There's a license resuspension on DUI second, if there's a conviction on that. We'll set this for a revocation hearing on August 31st. Mr. Mead, if you are revoked, I'm not going to impose, I'm almost certain, anything more than the mandatory minimum. You're interested in salvaging and again, as I indicated back then, it's an SOC order of condition. That's a contract between yourself and the city. I'm sort of just the arbiter of the agreement. I don't.
what is this?
Pardon?
What is this?
Stipulated order of continuance. That was how you resolved the case back then. That's an agreement. If you do certain things and don't do certain things, don't reoffend, et cetera, you get a pretty good break, you know, reduction in sentence, a reduction in charge, dismissal of the charge. And the city is alleging you violated the agreement by not doing what you obligated yourself to do. Now you can get a copy of that SOC from us or from the prosecutor to review it. We're setting up a revocation hearing at this time. What I suggest you do is we'll make sure that your attorney is present, and you can, if there's the possibility that if you're going to resolve this to your success, to your satisfaction, preserve the agreement, you're going to have to prevail upon the city or convince the city that you're serious about complying with the original. The city ordinarily bends over backwards, you know, again, main interest here is public safety and making sure you don't get into a legal situation where you have to go back to court on a new violation. That we don't want to see that. Mr. Mead, based on your record, best I can advise you is to, if you can, move heaven and earth to come into compliance with the agreement. Again, you can get a copy of that agreement with us or with the.
May I ask prosecutor's number so I can call?
Who represented you, I think? So you had a private. You did have you were represented originally by a private counsel who's withdrawn, so you don't have an attorney by now. If you're in, I'll appoint. Yeah, Corey Wood evidently represented you back when they in 21. I will appoint a public defender to represent you if you're indigent request. And could we put Mr. Haverford? I'm appointing him at this time. Mr. Haverco's address and telephone number is now in today's order. You can give him a call, and as far as prosecutor is concerned, probably I would advise you to contact the prosecutor through your attorney. And we'll advise Mr. Haverco that he's appointed to represent you. You are working, you are employed. That's a step in the right direction.
That I'm trying.
The important thing is we all get knocked down. The thing is get back up. Don't give up.
Yeah.
Don't give up.
May I ask, how long, long,
Pardon?
how long is treatment, be for long for the Allen?
I'm the wrong person to ask on that. That's beyond my professional expertise. I leave that up to the treatment providers. They talk to you, look at how things are going. They make an evaluation based on a number of things that I don't know anything about.
Yeah.
But I'm going to leave it up to them how long treatment lasts. Yeah, I once heard a response to that is doctor, how long do I need to be treated for that? And the doctor said, how long did it take you to get sick? That was, that's true. But Mr. Mead, I'm going to wish you the best of luck. And the important thing is I'm not aware of anyway, at least any new alcohol related offenses, and that's a fine thing. Good luck. We'll see you back here in a couple of weeks, and take care of yourself. And again, we'll advise Mr. Haverco that sometimes it takes more than we have to get. Sometimes I'm like a mule. You got to hit me over the head a couple of times before I get it. But Mr. Mead, good luck. You take care. You get a copy of today's order at the window outside the courtroom to your left, and you take care of yourself. Good luck. Andy Peterson. Answer, how about Adam Kevin? Andy Peterson. Well, looks like same issue we're dealing with once again. How's treatment going?
Oh, I've been doing treatment. I got out of IOP. I'm in aftercare. Mommy was supposed to send something to here. She told me she sent something.
Filed August 2nd. Doing well. We do need victim impact panel. You have that scheduled? Would it be possible for you to schedule it through CMAR?
Or it says, is what, what's,
Victim impact panel, that's usually just a couple of 3-hour session where you hear from a few people who've been affected by
Oh, and I've been
DUI.
just doing IoT and aftercare, and I got with Momi and they did a assessment and that's what was my thing, so I went and done. I didn't know I was supposed to go to a victim plan, I just know that I was in CMAR behavioral health doing my classes.
We do have treatment reports and it looks like you're doing very well in treatment. We don't have the assessment. And usually, yeah, that's, these facilities, they're very good at providing treatment. The problem is they're not very good about providing torts with proof of.
That was in November of last year when I did my assessment and
Yep. What, and sometimes you have to jump on them with both feet. They get busy providing treatment, dealing with their emergencies that come up on a regular basis. So what I'd like to do is talk this over a couple of weeks and give you a chance to, yeah, I'm quite sure that the assessment, it always does recommend a victim impact panel as well. That's just part of the almost any recommendation we get. It's a very simple thing to comply with and do. And very, very informative. The,
I didn't, Momi, or I can do that,
yeah, well,
Momi, I was just following what Momi's been doing.
that's well, check with CMAR. Tell them that that I indicated that's maybe this is just a misunderstanding, Ms. Peterson, let's knock this over to the end of the month, the 31st. Unless the city has any, and we'll deal with it. We'll deal with it then.
Okay, so you just need me to go to
Go to CMAR, get a copy of the assessment. Make sure it might be. You might have better luck if you say, "Hey, give me the assessment. Don't send it to the clerk. Give it me, and I'll take it in." So, talk to them and see what they'll do. And yeah, and if the assessment does not recommend or is willing to waive the victim impact panel, so be it. So be it. But usually I have to assume that would have been with the recommendation because it always is. But how's life going otherwise?
just been working full time and doing my classes and getting my fines almost done. I only have like 200 left, so.
That'll be behind you before you know it. Then you'll look back on working full time.
Yeah.
That was.
And
Are the
on
classes?
Wednesdays and try to have one day off on weekends, so I try to have my self-care there. I mean, try to relax. Cause I'm on a go from Monday to Saturday.
But are the classes doing you any good? That's sometimes it's just a hoop to jump through, and other times people, yeah, man, I learned a lot. And
I do learn a lot. I do learn a lot from Momi in the classes. I'm in aftercare, so I do it once a week on Wednesday. And
that's
that and going to AA and stuff like that. So
and that's all, and hear all the bad stories about misfortunes of one kind. We're lucky we're just here, I guess. So, Ms. Peterson, I'll sign today's order. You can get a copy of it at the window outside the courtroom to your left, and I'll see you in a couple of weeks. Let me provide this. If we have on file a proof of a copy of the assessment, and if CMAR says, hey, victim impact panel is the thing to do, and you have one scheduled, if you have that on file here, you don't need to show up.
okay.
Might be a good idea to give us, we're setting it for August 31st. Might be a good idea to give a call to.
Yeah, she's out of town too.
Oh, boy.
I'll try to, I don't know when she'll be back from Hawaii. I'll talk to her.
Well, that's, we can always not let that stand anyway. Let us know and we can always reset it for out a little further.
Okay.
Ms. Peterson, good luck. You take care. Thank you for your patience. Have a good day.
Thank you.
Well, we had the expected no-shows. I see with regard to docket number 4, city is going to dismiss. The defendant is in prison with a the order. The city has, Brent has a little form, order of dismissal.
I can.
We do have the order of review. Those we can just dismiss. Washington warrant. Yes, sir. Mr. Santos. Um. Santos, I'm finishing up a matter here. We'll. Don't worry. Signing as we speak. Santos, we did have you on the 8:30 calendar. You were being held at the Nisqually jail with regard to I think Lacey had a hold on you. They must have released you on that. You're here for arraignment. We'll have the public defender on here shortly. When we do, we'll take your matter. Mr. Santos, did you talk to the Yelm public defender? It looks like you did. That's well, we don't have him on the on Zoom appearance, and then he'll be here in person later. We may want to wait until would it be convenient for you to come back later in the morning? Oh. And where do you have to be? Pardon? What time? Why don't we reset you to the August 31st? I don't want to. It looks like you have a we can, yeah, no, if you've got an agreement, you've got an agreement, and we'll go back to that. Just why don't we process it? I don't want you to be late for your appointment here, and I'm afraid if, given what we're dealing with today is, if I might not be able to let you go here before. So why don't we reset you to the 31st of August, okay? Give them a court date. Oh, put them on 10 o'clock. I've got it. Pardon? Pardon? Right now, we're just gonna set it for in person, but I want you to talk to Mr. Haverco. He's the public defender you talk to. It's a order appointing counsel. I'm gonna. Will his, if I edit that, will his, there you go. Got it. Mr. Santos, Mr. Haverco's contact information is on the order on today's hearing. You can get a copy of that at the window outside the courtroom to your left. Get a hold of him and see if he'll arrange that if necessary, okay? Mr. Santos.
Morning, Judge. I can't hear anything. Can't hear.
I can hear him, but he can't hear me.
I can now, Judge.
Okay, you got it?
Yeah. It was like you were muted first, but now I can hear you. Yeah.
Perfect.
Okay, Mr. Burnham, why don't you go ahead and have a seat?
Mr. Burnham, good morning. Is your name Ren Michael Burnham?
He's by the way, Judge, they're not letting him have his hearing aids, and the volume coming out of the computer system here, it's pretty low. It's not, I can hear you, but he's having trouble hearing you.
Mr. Burnham, are you able to hear me now?
Yes, Judge, barely, but yes.
Hey, good morning to you.
Good morning, sir.
I'm appointing Mr. Haverco to represent you, and I'll hear from him at this time. You're here for an arraignment.
So what he said was, he just appointed me to represent you. And he advised you that you're here for what's called an arraignment.
Okay,
And so, Your Honor, just, I had an opportunity, the city, provided me a copy with the police reports in this case, and I had an opportunity to discuss the case, the reports, and the evidence that the city has with Mr. Burnham. And I believe the parties, in light of that, have reached an agreement, and I have prepared a stipulated order of continuance electronically in O courts, and the proposed agreement is that both charges would be continued for 12 months on the condition that he remain law-abiding and pay a $250 court fee. He may want to pay it all at once, but I would suggest just issuing a time payment agreement. But I suspect he'll probably pay it all. And then what the city would agree to do is at the end of the 12 months, they would move to dismiss both charges.
Mr. Burnham, are you able to hear me now?
barely.
Does it help if I speak up, or is that just,
That's a little bit better, Judge.
is that better?
That's a little bit better, yes.
It looks like you have an agreement with the city, as long as you stay out of trouble. No violation of any, no contact orders, no legal issues, these charges will be dismissed. Now, if you violate the agreement, we'll have a hearing based on the police reports, and that would result almost certainly in a conviction for two pretty serious offenses. You realize that?
Yes, sir. Yes, Judge.
Have you gone over the agreement with your attorney there?
I'm in agreement, yes, Your Honor.
Do you have any questions you'd like to ask me?
No, Your Honor.
Hey, I'll sign off on the agreement. Now, you're going to get a copy of this, and I want you to go over that carefully and call Mr. Haverco if you have any questions. Now, do we have a good mailing address for you?
Didn't you tell me that you now have a PO box?
I do have a P.O. box, yes, Your Honor. And I've already filled out the change of address.
Do you happen to know the address that you could tell the judge this morning?
Hmm?
Do you happen to remember what the new address is that you could tell him?
The P.O. box?
Yeah.
I don't know exactly. It's 1762, I believe.
Now, Mr. Burnham, can you do this? Could you give Mr. Haverco a call and tell him what that address is? And I'm just told that we do have that address.
Oh, okay.
We do have that address. So I want to thank you for that. Mr. Burnham, you stay out of trouble, abide by the law and the agreement. A year from now, these charges will be dismissed. They'll go away completely.
Thank you, Your Honor.
I want to wish you the best of luck. You'll be released today without bail.
Thank you, Your Honor.
Thank you, Mr. Burnham, and good luck to you.
Thanks, Judge. Oh, what's that? Oh, he's not coming to work? No, he refused. What? What? Is there a moment I could talk to him briefly after I know the details? Yeah, we can do it. Okay, I mean, is he far away? Okay, please, okay. Come in, Paul. Can't hear you, Judge.
I'll try again. How about this?
That's a lot better.
I guess I'm just gonna have to speak up today. But go ahead. Is this Mr.
Well, this is Paul Harvey Scott, and he's got a couple of cause numbers on today, but one of them comes before the court for arraignment on a criminal trespass second degree charge, and I had an opportunity to discuss the case with Mr. Scott. The city provided me a copy of the police report. And he has decided to enter a plea by way of an Alford plea. And while he doesn't necessarily agree with the facts themselves, he nevertheless agrees that the facts and the evidence that's available to the city, were it presented to a finder of fact, along with any evidence Mr. Scott might have, he would agree that there's a high likelihood that a finder of fact, jury or judge, would enter a finding of guilt. Because of that, he's also entering a plea to take advantage of the city's offer, which is credit for time served. And so I'd ask your honor to inquire. There is a statement of defense on plea of guilty in the Old Courts system.
Mr. Scott, good morning. I'm looking at a statement on plea of guilty to one count of criminal trespass in the second degree. Have you gone over that form with your attorney? I'm appointing him to represent you in this matter, of course.
Yes,
And I understand you're waiving arraignment and wish to proceed to a disposition.
yes,
The plea form tells me you're 38 years of age. Any problem understanding the plea process with your attorney?
no,
If I accept the plea, you could get up to 90 days in jail and up to $1,000 by way of fines, regardless of what's recommended. You realize that?
yes,
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing.
okay, yes,
Now, I understand this is an Alford plea, which means you've reviewed the matter with your attorney, gone over the reports, and believe that if the matter did go to a trial, that it could go badly for you. And you want to take advantage of the plea bargain. Is that correct?
yes. Correct,
With that in mind, as to one count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on June 23rd. Excuse me. On August 8th, 2023, how do you plead guilty or not guilty?
guilty,
Do you make that plea of your own free will?
yes,
Anybody make any threats or promises to you to make you plead guilty?
no,
I'll find the plea freely, knowingly, and voluntarily made. Do you want to tell me anything?
I didn't know I was in a different part of the property. They had told me before that it was different owners, but then I didn't know. I mean, it was another whole different part of the property. I'm sorry. I'll move my stuff as soon as I can, and it won't happen again.
Mr. Scott, it seems like this is almost a monthly process that we speak to each other, you in custody and me here in Yelm. I would like to do something to end this, but I don't know what it is. I'm just going to remind you, you're building up a lot of suspended time, yours, I believe at this point. Stay out of trouble.
Okay.
If there's any question about where you can or can't be, you better make sure that you're not supposed to be there.
Okay.
And of course, if you draw attention to yourself, that just makes sure that the situation is exacerbated a little bit. Good luck to you, okay?
Thank you.
Thanks, Judge.
You know, might not be a bad idea if you laid off the substances.
Okay. All right. Thank you.
What do you do?
Go ahead and have a seat in the brown chair over there.
And of course, it's waxed on the
Oh, you want?
compliance.
Okay.
Good morning.
Good morning.
Morning, Judge. This is Kevin Jones, and he's got a couple of matters on today. And one is on for an arraignment, and that's for criminal trespass second degree. I did have an opportunity to discuss with Mr. Jones the evidence contained in the police reports on that arraignment case that was provided to me by the city. And I believe based on that, he would like to waive arraignment. He understands that the arraignment, he's entitled to enter a not guilty plea. Be read his rights, be read his rights, elements of the charges, the maximums that can be imposed. He understands the charges, the rights that he has, but pursuant to an agreement, he'd like to waive formal arraignment, and pursuant to that, I prepared a statement of defendant on plea of guilty for Mr. Jones. I anticipate he's going to be entering a straight plea of guilty to the new charge of criminal trespass second degree. And then as part of the agreement upon the court's acceptance of that plea, the city will then move to dismiss his prior case ending in 043 that comes on before the court for a pretrial hearing.
Mr. Jones, do you disagree with anything that Mr. Havercoat just said?
No.
I'm looking at a statement of defendant on plea of guilty to one count of criminal trespass second degree alleged to have occurred in Yelm on August 3rd of 2023. Plea form tells me you're 36 years of age. Any problem understanding the plea form with Mr. Havercoat?
No.
If I accept the plea, you could be sentenced up to 90 days in jail regardless of what's recommended. You realize that?
Yes.
And if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, just a sentencing.
Sounds good.
With that in mind, as to one count of criminal trespass second degree alleged to have occurred within the city of Yelm on August 3rd of this year, how do you plead, guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty?
No.
I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. Recommendation as to sentence is pretty standard here.
Yeah, just all suspended time, Judge. Just suspended for 12 months with conditions of no new criminal law violations.
Mr. Jones, anything you'd like to tell me?
Just the basics, just all,
Mr. Jones, I don't like to keep people in jail, except I sometimes have to because I think that's the only way I'm going to get them into a courtroom. Does the city have anything to add? I'm going to follow the recommendation. The charge dating back to July 28th is dismissed. Imposed 90 days, all suspended on the condition you simply have law-abiding behavior. Mr. Jones, any questions at all?
No.
No, that's the keys to the jail are in your pockets there. Stay out of trouble. You won't get arrested and go to jail, and you won't get any suspended jail time imposed on you. I'm going to wish you the best of luck. You'll be released unless you have some other holds on you. Stay out of trouble, okay?
All right, thank you.
Good luck to you, Mr. Jones.
Thank you, Judge. Go ahead and have a seat in the brown chair. Okay.
Go ahead, when ready.
Oh, thank you, Judge. So this is Mr. DeFord. He's got 5 matters on this morning. 3 pretrial matters and a couple of arraignment matters. I've been provided police reports by all the matters, including the new matters, and I've had an opportunity to discuss the police reports with Mr. DeFord on all of his cases, and including, again, the 2 arraignment matters. He'd like to waive formal arraignment. He understands he has the right to be read the charges, each and every one, in open court, and the maximums that can be imposed, and his rights. He understands his rights. He understands the charges. I believe the parties have reached an agreement. He'd like to waive arraignment on the 2 arraignment cases. And then there's a lot of matters on this morning, so I'll just kind of read them off. So on the item number 2, that's the one ending in 395, he's going to enter a guilty plea. On item number 3.
I didn't quite catch what that you were talking about, docket number 2.
Oh, but can you hear me a little bit better now?
Yes. Oh, yeah, much
Oh,
better.
sorry about that. The microphone. So let's give it another try. So I've had an opportunity to review all of the matters with Mr. DeFord. And as to the item number 2, ending in 395, he's going to enter a straight plea of guilty. As to item number 3, ending in 399, he's going to enter a plea of guilty. As to item number 4, city is going to move to dismiss as part of a global agreement. On the arraignment case number 5, he's going to plead guilty to count 1, which is possession of a dangerous knife. The city is going to move to dismiss counts 2, 3, 4, and 5 on that case. So he's only going to plead guilty to 1 count on item number 5, that arraignment. And then he's also going to enter a plea on item number 6, which is the loan, loitering, drug-related activity case. So I prepared a statement of defense on a plea of guilty, and it enumerates all of the different dates in question as to each offense. And so it's a little bit elaborate, but ask your honor to inquire.
Good morning, sir. Is your name Kinsey Lee DeFord?
Yes, Your Honor.
Mr. DeFord, I understand you're an enrolled member of the Puyallup tribe.
Yes,
Is that correct?
yes, I am.
Now, do you disagree with anything that Mr. Haverco just said? He's the public defender standing or sitting beside you. I've appointed him to represent you in this matter. Do you disagree with anything he said?
No, I do not.
He's indicated that you're willing to waive arraignments on all these charges and enter pleas to dispose of several of them. Is that correct?
Yes, yes, Your Honor.
Have you gone over the plea form with Mr. Haverco?
Yes,
And you understand that if I accept the pleas, I can impose up to the maximum sentence on each charge with criminal trespass. Second degree, that'd be 90 days in custody. With regard to possession of dangerous weapons, that would be 90 days. And likewise, with regard to loitering for drug-related purposes, that would be 90 days as well.
yes, Your Honor.
You understand that?
Yeah,
If I accept those pleas, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentence.
yes, Your Honor.
Now, I'm going to ask you as to 1 count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on May 23rd, 2023. 1 count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on June 4th, 2023. 1 count of possession of a dangerous knife, alleged to have occurred within the city of Yelm on August 6, 2023. And 1 count of loitering with regard to drug-related activity, alleged to have occurred within the city of Yelm on July 20th, 2023. As to those charges, how do you plead?
Guilty.
Guilty or not guilty?
Guilty.
Do you make those pleas freely and voluntarily?
Yes, Your Honor.
Anybody make any threats or promises to you to make you plead guilty?
No, no, Your Honor.
I will find the pleas to be freely, knowingly, and voluntarily made.
Yes, Your Honor.
And I reviewed your statement in paragraph 11. I do find that that satisfies the factual elements of the offense. With regard to sentencing, I'll listen to your attorney first.
Thanks, Judge. You know, the recommendation is, it's just time served on everything. I don't believe the city's asking for any kind of fine. So just essentially all suspended jail time for 12 months on the condition that he may remain law abiding, no criminal law violations. And he and I did have a conversation about, an intelligent conversation about use of controlled substances and kind of what's going on with him. And so he seemed to be talking to him sober in the jail. He had a lot of thoughtful things to say and had some insight about his situation and, you know, yeah, that's right. And yeah, apparently he does have some treatment scheduled. Where are you going and when are you going to start?
North Point in Edmonds.
So apparently he has an appointment to go into something called North Point in Edmonds. And I did wind up speaking with his mother, and she's worried about him and hopes that, you know, she wants him to get help as well. So just threw that in.
Redfield, anything to add? Mr. DeFord, you have a right to tell me anything you think I should know before I impose sentence. Is there anything you'd like to tell me? You don't have to say anything, but now would be the time if you have anything to say.
I feel good, Your Honor. I'm really excited to show my face at home and with my mom and back at the tribe and get into treatment. I'm actually really grateful for the last 2 weeks that I've been in jail. And that's all I have.
Mr. DeFord, I don't like to keep people in jail, but given the number of offenses you've racked up in a fairly short period of time, and it's apparent to me that they're substance related in nature, each and every one of those charges. That I'm going to follow the recommendation in part. I will impose 90 days on each charge, but suspend all of that on condition that you have law-abiding behavior, stay out of trouble, no consumption of any controlled substances. I'm also going to require that you obtain a drug and alcohol evaluation through the Puyallup Tribe's adult services and comply with any recommendations imposed or required of you in that recommendation. I want proof of that filed within 90 days. And I'm going to request that the Puyallup Tribe advise us if there's any violation of the court's order today. Any question at all?
No, Your Honor. Thank you.
You'll have contact information with Mr. Haverco. What I want you to do is review today's agreement and review today's sentence and call Mr. Haverco if you have any questions. And I'm going to wish you the best of luck. The record you've run up here in a very short period of time indicates that it's now you've got to address the situation.
Yeah.
If you don't, I'm afraid that you're going to be one of the I don't know how many individuals I've dealt with that I know I'm not going to be seeing again because they went. I'm sure you've got friends that may have gone that way yourself.
Yeah.
I'm going to wish you the best of luck. I want you to save your own life. Okay.
Okay.
I'll be hoping that you do just that.
I will.
I'm not going to set a review hearing at this time. I want you to. That's another condition. Keep a current address on file with the court. And if we may be sending you a request to appear for a review if I don't receive a copy of the drug and alcohol evaluation within the next 90 days.
Okay.
I know your tribe is very good about facilitating evaluations, and that can be done in far less than 90 days.
Yeah.
Mr. DeFord, good luck to you. You take care of yourself. Do you have any questions?
No, I don't. Thank you.
You'll be released unless you have any other hold.
Okay.
Good luck.
Yes, sir. I'll see you. I'll stop by on better terms.
Please.
Okay, thank you.
Who do we have left?
This is the longest. Is there anything in there about the Puyallup tribes? Way down towards the end of it. This is the longest.
Okay.
Well, Judge, I guess, right, Mr. Santos bailed.
He
So-
did, he showed up here in court.
Yeah, and I think I think you appointed me to him.
I did.
Okay,
We
and
re-
then, okay, and then just to update the court here, we'll need to reset all of Mr. Trevino's matters. He is currently apparently in detox. Coming off of, fentanyl or whatever it is, and apparently physically speaking, I guess he's just kind of not in bad shape and just says he's not gonna get up.
We'll reset Mr. Trevino.
Yeah. So I'll see Mr. Trevino in a couple weeks.
Oh, boy. I'll wish him well. That's I understand detox with fentanyl is pretty darn rough.
Yeah. So I will, thank you, Your Honor. I'll see you at the courthouse.
See you in a few. I gave Mr. Santos your contact information in the order resetting him to the 31st. He
Oh, okay,
had an appointment for his prosthetic.
okay,
In the
great.
hour.
Right.
Given
Thanks,
today,
sir.
we thought that best to just,
Okay, thank you.
hey, take care. Never goes en route. Do we have anybody on? We do have the one 9 o'clock. Yeah. Okay, let's. Good morning, Mr. Sanders. I want to thank you for your patience. Things have been.
Well,
going
thank
slowly.
you, Your Honor. I'm kind of first or second in the queue to continue an infraction here in a minute. If the court will let me do a 30-second pause when I get my name called over there, if that would be okay. I have Robert Rollins this morning. He's joining us remotely from home in Texas this morning. Moved there this past spring.
Okay. Is he, we have a Zoom user, but unidentified. That may be Mr. Brown. Aha. The Zoom user, could you identify yourself if you would?
This is Robert Rollins.
Mr. Rollins, good morning. Your attorney is also present by way of Zoom. I'm going to turn to him with regard to the status of the matter at this time. Are you able to hear me okay? We're having audio issues here.
Yes, sir.
Hey, thank you. Mr. Sanders, go ahead. Mr. Sanders, you've muted yourself.
Your Honor, I believe he mentioned on another.
Oh, okay. Yeah, that's, nope.
Amazing. What
That was a little
attorneys are
garbled.
capable of now.
Boy.
All right, we're back, Judge.
Okay.
Thanks for your patience.
Mr. Rollins, your attorney was briefly engaged. Otherwise, we'll address your matter at this time. Mr. Sanders, go ahead.
Thank you, Your Honor. I believe the city will have a motion and then we'll be ready to proceed on a change of plea to 1 count of reckless driving. And then at sentencing, the court will already have a copy of an alcohol assessment on June 15th and completion of ADAS and victims panel on July 22nd. I did have an opportunity to review the O Court's document with Robert. He understands what he's entering a guilty plea to, that he will not be having a jury trial, that he'll be giving up the rights that we have listed in paragraph 5 on our plea form. It's a city recommendation for a 24-month suspended sentence. All the jail suspended. There'll be some fines and assessments, a 30-day license suspension with the Department of Licensing in Washington. And I believe he's prepared to make a knowing, voluntary, and intelligent change of plea to 1 count of reckless driving.
Your Honor, if he moves to amend the charge. Right.
Good morning, sir. Is your full name Robert Forrest Rollins?
Yes, sir.
You disagree at all with anything your attorney just said?
No, sir.
I'm looking at a statement of defendant on plea of guilty to 1 count of reckless driving. Plea form tells me you're 34 years of age. You've got 12 years of education.
Yes, sir.
Any issues at all going through the plea form with your attorney?
Not at all.
Any questions you might have had, were they answered?
Yes, sir.
Reckless driving is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I would be free to impose that up to the maximum, regardless of what's recommended, if I saw it appropriate to do so. You realize that?
Yes, sir.
If I accept the plea, you give up the rights contained in paragraph 5. No trial, no appeal, simply a sentencing. With that in mind, as to 1 count of reckless driving alleged to have occurred within the city of Yelm on April 23rd, 2023, how do you plead, guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. The recommendation as to sentence is in the plea form. Does the city have anything to add?
Nothing to add, Your Honor.
Mr. Sanders, anything you'd like to add to the sentencing recommendation?
No, Your Honor, I think it's all clear. Thank you, Your Honor.
Mr. Rollins, you have the right to tell me anything you think I should know. You don't have to say anything, but if you have anything that you think I should know, now's the time.
I was going through kind of a rough patch in life, you know. I understand that mistakes were made on my end, and I don't plan on repeating such mistakes. So I've been doing, you know, whatever needed to make sure I reprimand those mistakes.
Mr. Rollins, you've got a very favorable plea bargain in this matter. I've said many times that a conviction for DUI is worse in terms of impact on your life than a lot of felony convictions. I think the recommendation is a fair one. 2 years of jurisdiction, all jail time, 364 days suspended on the condition you have law-abiding behavior and pay a $250 BAC fee, $102.50 law and justice fee, and the $43 conviction fee. The least important thing to me is the money. The most important thing is that rough patch in your life is behind you, and you're not going to be back in front of any judge on a similar offense.
Yes, sir.
Any questions at all?
No, sir.
Mr. Sanders, anything further?
No, I think we're in good shape, Your Honor. I had to play with the judgment and sentence. I started to put the LCJA $102.50 over on TPIA. You'd think I'd have all those letters down by now, but I think our JNS looks pretty good too.
It's the law is becoming alphabet soup. Mr. Sanders, I thank you very much. You take care of yourself. Mr. Rollins, I'm going to wish you the best of luck. We'll be sending you and your attorney a copy of the paperwork today, the plea and the judgment and sentence. Go over it carefully, and if you have any questions, of course, give your attorney a call, okay?
Yes, sir.
Once again, I wish you the best of luck. I hope the weather down there is treating you.
Thank you.
Take care of yourself.
You too.
Thank you, Judge.
Have a good day. And with that, I think we'll go off. Unless we have something else, we'll go off. Van Erickson? Yeah. I remember. Driver call?
I think the parties have reached an agreement on case number, it's item number 5. Matter comes on for pretrial hearing for suspended first degree charge. Skinning or a straight plea of guilty to the amended charge of suspended driving in the second degree. And pursuant to the plea agreement, the city will then move to dismiss his other suspended first case, which is item number 4, ending in 400. I put in a motion in the reports. I wasn't sure if it was the right motion for that, because they're not, the cases aren't joined.
Yeah, they're two different cases. That's that would work, I guess. Yeah, that's with regard to 3A. Blank by blank, last 3 digits, 400, 400, just flat, straight order on motion. Move to dismiss. So ordered. You heard if you want to sign off on that, and Mr. Erickson, in a moment, for the record, it was Michael Erickson. I want to thank you for appearing. I will be looking at a statement of defendant on plea of guilty to 1 count of driving a license suspended or revoked in the second degree. That's still a gross misdemeanor, the maximum penalty on conviction of the 364 days in jail and or a $5,000 fine. I would be free to impose that regardless of what's recommended, if I saw fit to do so. If I accept the plea, you give up the rights contained in paragraph 5 in the plea form, no trial, no appeal, simply a sentencing. Any question about that? With that in mind, as to 1 count of driving a license suspended or revoked in the second degree, alleged to have occurred within the city of Yelm on May 15th, 2023. How do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make it plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Regard to a sentence, Mr. Havertz?
I believe the city was just recommending suspended time, you're in jail, all suspended, conditions, don't drive without license and insurance, no criminal law violation, $250 court fee. I guess he's recently done full year in jail on his other suspended first. So, still has some other matters to deal with.
Mr. Erickson, I'm going to assume by now that you're tired of Thurston County and its jail. That's it. That was, that's. Understand, I don't pass the law. I just, what it is. And for whatever reason, driving a license suspended or revoked in the first degree has mandatory jail time at a certain point of a lot more than any other mandatory minimum to be imposed in any other case.
Might want to plug in.
Any idea that's about your licensing situation, what you can do to Yep. I would make sure that you follow through on that. It's a laborious process, and the money involved is it's kind of pricey, okay, you know, especially the SR22 insurance.
Yeah, I got it.
especially. But yeah, I'm gonna wish you the best of luck with that. Get a copy of today's paperwork at the counter out the door to your left, and good luck to you. That's it. Don't give up on getting your license back. I want to see you out there legally, okay? Take care of yourself. And bond exonerated. Yeah, he's the guy that we couldn't get the
Proposed in an agreement. We don't have-
Well, that's his choice, I guess.
We proposed a 12-month.
I'll take your word that he agrees with the,
It's a 12-month proposed stipulated order of continuance. The case to be continued 12 months on the condition, I forgot to put it in the form, but it's just no new law violation. 254 feet and what needs to be added to it, don't go back to the.
we can certainly do. Any objection to the addition of the barring from the Yelm wall? Ms. Marina, for the record, your name is Emma Benita Bell Marino. I'm looking at a SOC stipulated order of continuance here at Oak Courts. That's what we call it. That's actually, it's just a contract, an agreement between yourself and the city negotiated by your attorney under the terms of which this charge will be dismissed 12 months from now, if, most importantly, stay out of trouble. Stay out of trouble. Don't go any place where you're not welcome to go, and apparently that includes the Walmart. If they don't want your money, that's their choice to make. Yeah. The monetary part of it, I believe, is a $250 probation monitoring fee. We'll put you on $25 a month. In return for this agreement, now you've given up your right to go to trial. If the city proves a violation of the agreement, the hearing will be based on a copy of the police report, and you know where that would go. We don't want to go there. You have a chance to have this case, this charge dismissed. You want that to happen. If we find you in full compliance a year down the road, that's a case will be closed with dismissal. Ms. Marino, any luck at all? Any questions at all? With that, I'm just simply going to wish you good luck, and I want you to get a copy of this agreement at the window outside the courtroom and to your left. Read it over carefully, and if you have any questions, give Mr. Hammerco a call, okay? Good luck to you. And I'm not going to insult you by trying to pronounce correctly your name, which I do not have the capability of doing. So, we go ahead. I'll defer to your attorney. Take a chance. It's Tonawall. Is that close enough?
Yes, sir.
No, that's.
So matter comes before the court on a pretrial hearing on a theft charge. Parties have reached an agreement. Charge is almost 3 years old. That being a stipulated order of continuance, conditions of which are continue the case 12 months on the condition of no new criminal law violations, pay a $250 probation fee, payments of $25 a month, at the end of which time city will then move to dismiss.
Again, you probably heard me say that a moment ago. It's an agreement, a contract under the terms of which this case is going to go away. It's going to be dismissed in a year. If you stay out of trouble and pay a $250 probation monitoring fee. The money's the least important thing to me. If there's an issue making the payments, make sure you let us know about that and we can deal with that pretty easily. And again, I need to repeat to you that if there's a violation of the agreement, you've given up your right to go to trial in return for this agreement. We'd have a hearing based on the police reports that would almost certainly result in a conviction and the possibility of jail. So don't want to go there. You have a chance to get the case dismissed. You want that to happen. Any questions at all? Anything to add from the city? That's it. Concludes the matter. And again, get a copy of the agreement. And I want you to, it's kind of lengthy. read it over carefully, and if you have any questions about what it means or any of the provisions in it, give Mr. Haverko a call, okay? Thank you and good luck.
Thanks, Judge. So this is Mr. Carlos Cisneros Chavez. He's number 1 on the 11 o'clock calendar. Matter comes on for the court for a pretrial. But I believe the issue will be a change of counsel. His previously a court-appointed public defender was Josh Sneva, is listed as the attorney of record. So I don't believe I have actually been appointed.
You now are. I hereby appoint you
on that
as
case.
the attorney of record for Mr. Cisneros Chavez.
Do you have a number?
Yeah. 360.
Now that you have a new attorney, need to reappear at September 14th. Conditions of release, of course, are law-abiding behavior. Stay out of trouble. Stay in touch with Mr. Haverko and be back here on the 14th of September at 10 o'clock. You can get a copy of today's notice at the window outside the courtroom to your left. Any questions at all?
No.
Take care of yourself.
Wait 1 second, because I have to have the signs.
There is Cisneros Chavez. That concludes the hearing. Get a copy of the notice at the window outside the courtroom at your left, and make sure Mr. Haverko knows how to get a hold of you. He'll be wanting to contact you before the next hearing.
Okay. Thank you.
This is Jenna White, and
Ms. White, good morning.
a couple of matters on today, one of which is a pretrial hearing on assault case. I think the parties have reached an agreement. She's getting a straight plea guilty to the amended charge of disorderly conduct. 90 days in jail, all suspended for 12 months on the condition that she has no new criminal law violations. Said he's not gonna ask for a fine based on indigency. She's homeless at the moment, living in her vehicle, so. So I just don't think she's in a very good position to. change.
You need a moment, Ms. White?
She's just, she's just having a lot of things that aren't going well right now. Her kids were, I guess, taken somehow, I don't know what procedure civilly, but her kids were taken away by her manager where she was living. She has a lot of stuff going on.
Ms. White, I'm sure you've heard that before. This too shall pass. This too shall pass. For the record, is your name Jenna Marie White? You could get through a hearing today and go on about your life. I'm looking at a statement of defendant on plea of guilty to one count of disorderly conduct amended down from an assault charge. Have you gone over the form with Mr. Haverco? And did you find yourself able to understand it and concentrate on it? Now, disorderly conduct is a simple misdemeanor. The maximum is 90 days or $1,000 in fines. I'll impose whatever sentence I think is appropriate after hearing from your attorney up to the maximum. You're given up the rights contained in paragraph 5, no trial, no appeal, simply a hearing resulting in a sentence. I'm going to ask you as to a count of one count of disorderly conduct alleged to have occurred in Yelm on April 13th of this year. How do you plead, guilty or not guilty? Do you make that plea of your own free will? Has anybody made any threats to you to make you plead guilty? I'm going to find the plea freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. The recommendation is all jail time suspended with no fine. To conclude the matter, Mr. Haverco, anything to add?
And yeah, just, just hope his wife is able to, sounds like she's just in a tough spot. Hope she's able to get some of this hardship behind her.
At least you're taking care of that one problem today. You won't have to worry about it as long as you stay out of trouble. Just one thing at the time. One thing at the time. Sometimes if I concentrate on the whole plate full of problems I have in front of me, it's just overwhelming to the point where I don't want to deal with anything. But I just try to take just one thing at the time. And next thing you know, you're through everything. Is there anything you'd like to tell me? I'm inclined to follow the recommendation and we'll do that. Ms. White, I want to thank you you came in and you very patiently waited for your matter to be heard. I want to thank you for that. And I want to wish you the best of luck and I hope all goes well. It's, as Zorba the Greek said, life is trouble. The alternative is not. I'm going to wish you the best of luck, okay? If you want a copy of today's paperwork, Mr. Haverco is going to have it for you, but you can get your own copy if you want by going to the window in front. I want you to just take one thing at a time, be patient with yourself and try and smile once in a while.
And I'm assuming we can just strike the review hearing matter.
Hearing no objection from Mr. Atfield, we're simply going to strike that. Ms. White, good luck to you. That concludes the hearing so just stay out of trouble and you won't find your way back here. Take care of yourself. You see, we have Ms. Buskirk on online.
Good morning, Your Honor. I apologize for my tardiness. I was on a client call and lost track of the time.
Good to hear from you. Take care. Hopefully the weather's kind to you in your neighborhood.
It is very nice, although the last time I drove out there, it was pretty beautiful. I parked far away just so I could walk a ways in.
We'll enjoy this cooler weather while we have it. But we'll address your matter now if you want.
Yes, Your Honor. I'm present for Mr. Turner, and I did load forms into O Courts. We're waiting for the evaluation. I think I put the date of the evaluation in there. He had to move to a new home. I'm waiting for his updated address. He was in the middle of moving when he talked to me yesterday. So he said his mail is forwarded, but he'll get me the new address. We're asking to set over, the evaluation is scheduled. I just sent over all the reports to the agency, so that should be done and completed at the end of August.
The order I have resets the matter to September 28th at 11 o'clock. Is that going to work for you?
Yes.
So ordered? So ordered, in touch with your client?
Yes, Your Honor. I talked to him yesterday.
Okay, great. Waive his presence. With that, we'll just send you a copy of the order resetting the matter, and you take care. Have a good day.
All right. Thanks. You too.
Talk to you the end of September. Take care.
Judge, I think the only matter I have left is on the 11 o'clock calendar.
We had an excellent rate of show today.
Yeah. Just about everybody. Yeah.
I think you're missing Mr. Dixon,
Yeah.
but I think that's
I
it.
texted, I had a number and tried to call the number and I got this strange message. Like, the services right now, you can't call it or whatever. But it didn't say it was no good exactly. So I did send a text and didn't receive any response.
Well, so ordered 1,500 cash. That's it. Yeah, that's pretty remarkable. Everybody. Now on record for the 1 o'clock arraignment calendar, Mr. Crow, you're present. I don't see a picture and you appear to be muted. Now you're muted. Are you able to hear me?
I'm here, Your Honor.
We're going to call your matter first. I understand you have appeared on behalf of Crystal Franco. Is she in the courtroom? She's in the courtroom approaching the council table and she's having a seat. Good afternoon, ma'am. Is your name Crystal Ann Franco? Yes. Ms. Franco, this citation alleges that on or about August 7th, 2023, you committed the offense of assault in the 4th degree DV. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this point, I'm going to turn to Mr. Crow, who's appeared on your behalf for the entry of a plea for you. Mr. Crow?
Good afternoon, Your Honor. That is correct. I'm appearing on behalf of Crystal Franco. We'd waive a formal reading of the charges against her and a formal reading of her rights, as I've gone over those with her extensively. Enter a plea of not guilty, ask that the terms and conditions of release remain the same, although I do have a question about that, and just ask that the court set a pretrial hearing. With regards to the terms and conditions of release, I'm not sure exactly what the situation is with the no contact order with the alleged victim, but we'd appreciate it if the court would consider entering a no hostile contact order. The couple has a child together, and they need to have some communication with regards to parenting. I believe the child might be special needs, and it really requires both of them to be able to communicate with regards to parenting. And we could even limit it to just with regards to parenting the child if you feel more comfortable doing that.
Do you have any?
I think that the city responds. I think that's a fair compromise.
Okay. Mr. Grove, first things first, as far as a pretrial date, we can go to the 31st of August or September 14th or 28th.
I'm looking at my calendar now. I could do the 31st of August would be fine.
Hey, is that going to work for you, ma'am? August 3rd. That's what we'll do then. Mr. Crow, I had written in the order of release, your client was booked. The defendant may contact Jeremy Franco's son to arrange a visitation with their daughter. You want me to expand that to allow contact with Mr. Franco?
Yes.
Trying to think of how to word that without causing undue friction between the parties. Would telephonic work? The make communicate telephonically regarding parental issues with the daughter?
Ms. Franco, if you're speaking, I can't hear you. I'm sorry.
She indicated through text or voice text is fine. We are having audio problems here. I should probably speak up a little bit.
I can hear you just fine. I can hear Mr. Ratfield a little bit. I can't hear my client at all.
She indicated that text or voice that would be just fine, and that'll be the order that the parties she may contact by text or voicemail with regard to, but only with regard to matters of involving the daughter.
Right.
Pretrial has been set for August 31st, 9 o'clock. Conditions release, of course, they've earlier been set. Those remain the same except as modified. And the other condition would be maintain contact with your attorney and appear for court as directed. Any questions?
Just to clarify, you said that was at 9 o'clock?
9 o'clock. Is that going to work?
That better than the 8 a.m. calendars used to work.
Okay. Your client did have a and your client did request to be allowed to return to retrieve more items of personal property from the house. I have no problem with that as long as it's done the way it was done before with a Yelm police officer.
I think that's entirely reasonable.
Okay. I think probably we'll print an order off the computer. You'll be able to get a copy of that. We probably better put that part of it in the got it. That's in the order as well. Yeah, we'll be sending your attorney rather a copy of today's order. You can get a copy before you leave at the counter outside the courtroom and to your left. And I say that for the benefit of everybody that's in here. I'm signing electronically the order as we speak. Complete. Ms. Franco, that concludes the hearing. Thank you for your patience in appearing, and we'll see you back here at the end of the month. You take care of yourself. Mr. Groh, thank you. That concludes the hearing. We'll be sending you a copy of today's order as well.
Thank you, Your Honor. I appreciate it. And thank you very much for getting me in early.
And thank you. Take care. I'll call the 1 o'clock arraignment calendar. Before I call you each up one at a time, let me first say this. If there's a private counsel matter, I always take that first. Lawyers, their clock is running. I hate to run up anybody's bill unnecessarily. Mr. Crow, our public defender, he's going to be here throughout the remainder of the day anyway. He will enter a plea on your behalf at this time. This is an arraignment, your first court appearance. The only purpose of this hearing is to apprise you of the charges, tell you what the possible penalties are, and then set the matter for a pretrial. A plea of not guilty has always been entered to, that's no great statement about your posture in the case. It's simply a way of preserving your rights until you can have a pretrial conference to discuss the merits of the case and resolve the case by agreement if you can. If you can't resolve a case by agreement, you always have the option of a speedy and public jury trial in the county where the offense was alleged to have been committed. First, I'll call Russell Ames. Ms. Russell, Mr. Ames, come on up and have a seat. Good afternoon. Is your name Russell? Full name Russell Joseph Ames.
Correct.
Mr. James, Mr. Ames, the citation I have alleges that you violated the terms and conditions of a protection order on June 4th, 2023. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days incarceration and or a $5,000 fine with regard to each charge. Are you asking for a court-appointed attorney?
Yeah, and I was just wondering if you got the paperwork that I submitted and was able to review.
There's a whole bunch of paperwork here.
Yeah.
I will appoint Mr. Havercoat to represent you. He will enter a plea on your behalf at this time.
Your Honor, would stipulate your probable cause, ask the court to enter not guilty, please.
Mr. Ames, pleas of not guilty have been entered on your behalf. Now that does preserve your rights. I know there's a lot of filings here. Those are matters that you have to take up with your attorney. And if there's the basis for any defense of the charges, that's presented through your attorney. If there's any motions regarding the charges, that's the subject of a hearing at a later date, not today.
Yeah.
And we're not gonna argue about the case today. Today, the plea is entered. The only stipulation is to probable cause for issuing the citations. And all that means is the officer had a sufficient legal reason to issue you the citation. That's a long way from proving that you did anything wrong by proof beyond a reasonable doubt.
Okay. Question two. Probably something I should talk to the public defender here. But this case is actually connected with the same case with Superior and District Court. And I have other lawyers that are trying to get this all legalized. I was hoping just for dismissal here on this.
That's not the subject for today. We don't deal with motion to dismiss. That's heard at a later date.
Okay.
But yeah, we have a lot of hearings today. We don't stop and try a case at the. We were going to do that. We'd have to move you to the end of the calendar.
Thank you.
Signing your promise to appear for your next court date. It's in the order.
It's in the order, Mr. Ames, and it will be September 14th, 10 o'clock. You're going to get a copy of today's order. I want everybody to, as they leave here, get a copy of today's order. Outside the courtroom, to your left, there's a window. Ask for a copy of your hearing.
Okay, now what do I do? I have other hearings in September. I don't have to schedule long meetings, unfortunately. Is that now? The fall on same day, can I have that changed possibly, or?
If you have a conflict, that is something you need to take up with Mr. Haverco.
Okay.
His contact information will be in, phone number and address, a mailing address, will be in today's order.
Thank
So
you.
that's something you take up with him.
Repeat it. That's good. It's on the paperwork.
Mr. Ames, take care of yourself don't forget to get a copy of today's order and we'll see you back here next month.
Thank you.
And you as well. Brian Averill in the courtroom, Brian Averill. Number of people won't answer. The end of the calendar, I review the case. If there was probable cause for the issuance of the ticket, a warrant will issue for the arrest of the person that did not appear. You've saved yourself a warrant by just showing up today. And for that, I thank you. Mr. Averill did not appear. How about Alexander Beltran Figueroa? Is your full name Alexander, middle initial A, Beltran Figueroa?
Yes, Your Honor.
Hey, thank you. Citation alleges that on or about July 31st, you committed the violation of disobeying the terms and conditions of a probation or a protection order. Once again, that's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Are you asking for a court-appointed attorney?
Yes.
I'll appoint Mr. Haverco to represent you, enter a plea on your behalf.
Thank you,
He'll
Your
do
Honor.
so at this time.
Thank you, Your Honor. I stipulate to probable cause as the court to enter a not guilty plea.
Plea of not guilty, as I indicated before, that preserves your rights pending a pretrial. In the meantime, conditions of release are law-abiding behavior, and that includes, being in not being in violation of any order of protection that's in existence. Any questions at all? Find the order of Mr. Beltran Figueroa. Get a copy of it at the window, and we'll see you back here September 14th. Thank you, sir. Is Garrett Coleman in the courtroom? Garrett Coleman. How about James Farmer? How about Heidi Hefner? Amanda Huestis. Ken Jones, Kenneth Jones. Good afternoon, sir. Are you more comfortable standing or sitting? Is your full name Kenneth or Kenneth middle initial M Jones?
Yeah.
Mr. Jones, the citation I have alleges that on or about August 6, 2023, you committed the offense of assault in the 4th degree DV. That charge again is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. If you're asking for a court-appointed attorney, I will appoint Mr. Haverco to enter a plea on your behalf and represent you in this matter. Mr. Haverco,
Thank you, Your Honor. Would stipulate to probable cause as the court or not guilty plea.
Mr. Jones, a plea of not guilty is entered on your behalf. We'll set the matter for a pretrial. Conditions of release are, I said when I talked to you, those remain unchanged, and that includes no contact with Kelly Malone pending any further court order. Pretrial will be September 14th at 11 o'clock. That and contact information with Mr. Haverco will be in the order that you get at the window. And of course, make sure Mr. Haverco knows how to get a hold of, contact you. Pretrial September 14th, 11 o'clock. Jones, I've now signed the order. See you back here next month, September. You take care of yourself. Sandra Keene. There's a way of mispronouncing a name. I'm going to do it. Is it Sandra Marie Keene? Citation I have alleges that on or about August 6, 2023, you were under physical control of an automobile while under the influence of intoxicants. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You're asking for a court-appointed attorney? Now that's not my decision to make. What I'm going to do is appoint Mr. Haverco to enter a plea on your behalf, Ms. Scheme, and the process works this way. Mr. Atfield, the prosecutor will contact the county and see if they are willing to accept jurisdiction over the case. They have jurisdiction. The matter is, will they accept it? And if that happens, the case will be transferred up to the county for further proceedings. But for purposes of today's hearing, we'll just simply put the matter on hold by a plea of not guilty. But Mr. Haverco will.
Thank you, Your Honor. So would stipulate to probable cause as the court or not guilty plea.
The scheme, the plea of not guilty preserves your rights. Conditions of release are simply law-abiding behavior. Don't drink and drive, and don't drive unless you're licensed and insured. Kelly lives in the courtroom by any chance? The order is now signed. You can get a copy of that at the window, and we'll see you back here next court appearance. Thank you for appearing and good luck. Pardon? It is my hope that when you come back here on September 14th for your next hearing, that we'll have some further information by then. That's what I'm hoping. Sometimes the way government works, the wheels grind a little bit slowly, but hopefully we'll have some information on September 14th. Take care. Kelly Lenz did not answer. John Lewis. John Lewis in the courtroom. Mr. Lewis, good afternoon. Mr. Lewis, you were cited for driving a license suspended or revoked in the third degree. The city might have a motion with regard to your charge.
Yes, Your Honor. City moves to amend the charge to no vault in the second degree.
It's now, yep, they change it from a criminal offense to a civil infraction. If you admit the infraction, it's $150 and that concludes the matter. Done. Now, the question I have is, do you know what you need to do to get your license reinstated? I'd make that a project.
Yeah.
Oh, boy. And that's one of the harder things to do is
I had the money.
it's money and geography.
The ability, go clear that.
So Louis, the assessment is $150. You can pay that at $25 a month with your first payment due September 17th. Now, the money isn't the important part to me. What I'd like to see you do is just get your license back up. So if you can't make a payment, let us know. We can deal with that. Right? Thank you, sir. Take care. Get a copy of the today's order at the window, and that concludes the hearing and hopefully the entire case. Take care of yourself. Suzanne Mendoza? Suzanne Mendoza does not answer. How about Ashton Nelson? Good afternoon. Is your full name Ashton, middle initial I, Nelson? So Nelson, the citation I have alleges in honor about August 9th, 2023. You committed the offense of theft in the third degree. That's a gross misdemeanor. The maximum penalty on conviction for that charge would be 364 days in jail and or a $5,000 fine. If you're asking for a court-appointed attorney, I'll appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time.
Thank you, Your Honor. Would stipulate the probable cause as the court did or not guilty plea.
Mr. Nelson, a plea of not guilty has been entered on your behalf. That preserves your rights pending a pretrial conference. I'll sign an order of setting that date.
Okay, so what you do before you leave it closed.
Nelson, that concludes the hearing. Set your next hearing for September 14th. Get a copy of today's order at the window before you leave. Stay in touch with Mr. Haverco, and we'll see you back here next month. Take care of yourself. Crystal Porter does not answer. How about Zach Stanley? Good afternoon. Full name Zachary, middle initial W, Stanley. Mr. Stanley, you were cited for DWLS, driving license suspended or revoked, third degree. The city may well have a motion to make in your case as well.
Yes, Your Honor. City moves to amend the charge to no vault in the second degree.
What just happened is this: you were cited with a criminal offense If you're convicted of DWS third, you're exposed up to 90 days in jail and up to a $1,000 fine. The city's amended it to a civil infraction. If you admit the infraction, I'll assess a $150 fine. That closes the matter. There's no possibility of any jail time. Done. I'll do that. Set your payments at $25 a month. Now, again, what I'd like to do is encourage you to get your license reinstated. Perfect. Perfect. As you no doubt know, pretty easy to lose it and a little bit harder, quite a bit harder to get it back. So now that you have it, keep it in effect. I'm signing an order to that effect, Mr. Stanley. You can get a copy of that at the window out front, and that'll take care of the matter. Good luck to you. Take care. I'm out of cases to call. I'm at the end of the calendar, but I still have more people I think came in while we started. Ma'am, did you believe you had court today? Okay. Oh, let's hold on a sec. Ma'am, they're in the back. Did you have court today? Pardon? Okay. Come on up and have a seat. I don't think you'd arrived yet by the time when I called your name, but your name is Amanda Ann Marie Eustace. The citation I have alleges that on or about August 2nd of this year, you committed the offense of theft in the 3rd degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to enter a plea on your behalf, and he'll represent you throughout the course of the case.
Stipulate the probable cause, Your Honor, ask the court to enter or not guilty plea.
Plea of not guilty has been entered on your behalf. That preserves your rights. We're going to set your pretrial date, give you contact information with Mr. Haverco. Order signed, and you can get a copy of it at the window outside the courtroom to your left. Please do so.
Yeah.
Thank you, ma'am. Yeah, if you have any questions, come on up, have a seat, and I have a lot of questions myself, and not all of them can be answered, but hey, no, that's. But go ahead.
I have a question and I don't even know if it's related to the person the people that I used to live with a long time ago when I was a kid.
I have no idea what the question is, and so I have no idea whether or not I have the answer.
Yeah. The people that I lived with when I was a kid, it was my aunt, had a daughter who's my cousin. And she didn't have any kids and she passed away with the same name as you. Isn't the attorney or somebody, because I don't know how to handle like any sort of stuff like that, and isn't it supposed to be like the person who's handling it, are they supposed to be prudent and wise in as far as like being?
Was there a will?
I'm not sure.
If there's a will, the will would appoint a personal representative. If there was no will, there's what the RCW 11.04.015, intestate succession that says what happens.
Oh, okay, I'm not sure, I'm not sure if they even look for one, I don't know.
Well, attorneys can do a search for the thing. What I would suggest you do is contact an attorney that does probate or estate work, and that's where you start.
Okay, well, then we need money for that. I just wanted to, I mean, I don't know, it seems like they should want the house cleaned up or whatever, or something, and I don't know, you look an awful lot like them, but we don't know if you're related or not. I was just wondering.
Whether I'm related or not.
I don't know.
Well, I don't know what the names are.
Carl Myers, Janet Myers.
I don't think that's a relation. I'm a Meyer, M-E-Y-E-R. There's no S on the end of my name.
Meyer.
Yeah, and this is a Carl Meyer.
Yeah.
I don't know of any Carl or Janet Meyer.
I was just wondering how I probably go about that and the person handling it, because I mean, I did live there, they were my aunt and uncle, and I didn't get to see them. They passed away a long time ago and I didn't get to see my husband. I just thought that, you know, instead of having the county come and destroy the place with all the furniture and everything in it. I mean, wouldn't it
Who's
be
living
better?
there now?
No, nobody is right now. And I would like to be able to, you know, because I plan.
You don't know who owns it,
Oh, yeah, I know. It's Jen.
and they're dead.
She just passed away. I got down. Yeah.
Well, I think you need to see a lawyer about it, but one thing I can tell you for sure is I don't have any relatives by that name.
And I understand, and I just didn't know how to go about that, or if I had to get a clean business license to charge this.
Well, a lawyer would know how to do that. There's ways of finding out where, if it used to be, you had to probate the state in the county where the
Sure, I could probably do something, it's just I'm really devastated.
well, all I can do is wish you good luck.
If I have to go to municipal court, does it have to be in the county in which the issue is?
No,
Oh, really?
no, if there's an estate to be probated, that has to be probated in Superior Court.
Okay, but
And
if I'm
the,
not in a state, there's some other issue. If I was to municipal court, could I go to municipal court in another county, in the county in which the issue is?
What do you want to do?
I'm not sure, because I don't know that much about the law.
Well, unless you know what you're gonna do, I don't know whether you can do it or not.
Okay, and I'd rather all be in RCWs or, right, RCW, or would that be, is there municipal?
That'd be a jurisdictional matter. Courts have various jurisdictions. For example, I can handle speeding tickets. I can handle traffic tickets, but I can't handle burglaries and murders and things like,
Oh.
it just depends. So that's,
Oh, thank you.
Hey,
I was trying to do that towards.
okay, you bet. You have good luck to you and you take care. You're entirely welcome. And you as well. Keep cool. Let's deal with this. Up for the 1 o'clock no shows. First one is Ryan Averill. There is a message from him in the file, since we have heard from him recently. So, next one would be James Farmer. I find probable cause for hit and run attendant and obstructing, 1,500 cash or bond each. Heidi Hefner. I find probable cause for hit and run. That was a parking lot accident. She actually blew a .275 on a PBT, but given her condition, they had to hospitalize her and couldn't process a DUI. But the hit and run was pretty solid. I find probable cause for that. The owner of the business saw her smack another car in the parking lot. 1,500 cash. Not a young person. Kelly Lenz, she was PR'd with a DCR evaluation, given the court date anyway. 1,500 cash or bond warrant. Probable cause previously found for disorderly conduct. And Suzanne Mendoza did not, she was in custody. I'm a little bit surprised she didn't show up. So. 1,500 cash or bond. I found probable cause when I spoke with her at the Nisqually Tribal Jail. Last one, Crystal Porter. That was a DWS third. And given the city's standing motion, but there was a note in the file that did not appear due to COVID symptoms or something. So I think on that one, just reset and reset with notice. And that leaves us with just one, I think, Garrett Coleman, for this morning's and this afternoon's calendar. Probable cause on the third theft, docket number 4, page 12 for arraignment. 1,500 cash or bond. And on the non-appearance on docket number 1, page 1, same thing, 1,500 cash. Either that, I just noticed what I've been saying. One more I should do. have a display proof of liability insurance. You asked for what they call a contested hearing, which means you deny that you committed the infraction. You may have meant to check the box for a mitigation here.
Honestly, I haven't been to court since I was like 16 for a speeding ticket.
That's a good
so
thing.
I was Googling and Google said to do contested.
Oh,
I just honestly, I was like asking everybody I knew, I was like, what do I do? And everyone's like, I don't know, Google it. So I Googled. So that's what Google.
oh, okay. Well, that's most people, insurance, it's a pretty easy, you did or you didn't. Mostly it's that $560
Yeah,
that people want to mitigate it, which means reduce the amount of penalty.
yeah,
And is that what you really want me to do? Is just reduce the penalty?
yes.
That was, and I'll be glad to do it. Have you gotten insurance since then?
Yeah, so basically what happened, which obviously I know, I'm not here to waste your time at all, but like I never get in trouble. So I'm like, and
Oh, no, things do, life
no,
happens.
and so my dad, the vehicle, as you can see on the ticket, the tabs are expired as well. The vehicle's been broken down for a very long time. And my dad, when that was my high school vehicle, it's been broken down. We flew to Arizona for his triple bypass surgery. And
Oh, whoa.
before he went under, he said, hey, by the way, I think the car's fixed. One of his buddies went over and fixed it. So my mom literally dropped me off at his house in Yelm, and I was on my way headed home with the vehicle. And I was under the impression that it had insurance. So then the reason why I got insurance on June 21st was because we flew home the evening before. And then that morning, my mom dropped me off at the car. And then I was waiting to hear from my dad whether or not he couldn't talk on the phone because he was in ICU. Or
With the
whatever.
triple, yeah.
Yeah. So then finally I got a hold of him on June 21st and he was like, yeah, no, I took it off insurance. So then I called on June 21st and got insurance on it.
Good.
Yeah.
Well, why don't we do this? I'll reduce it from $559 to $150, set your payments at $25 a month, and maybe you can talk him into paying it for you.
Okay. Is there any way you could do it for a non-traffic? So
Is this a moving or a non-moving? I think it's a non-moving violation.
Is
The
it-
difference it is, Sonia, do you have a way of looking that up real quickly? Because they changed that. Yes, if it's a moving violation, that could have an impact on your insurance.
yeah,
If it's non-moving, and I think it's non-moving because it's a status, but there's a list,
right. Yeah.
and I'm not sure. Were you able to find out whether it was, there's a Washington Administrative Code provision that I have to look at every time because
Right.
they change it.
Is this how court usually goes now? I was used to like a big room of people. So this whole time I'm like, oh God,
Oh,
I'm
no.
talking in front of people.
Oh, you should have been here. You should have been here earlier. We had pretty much every chair filled.
Oh, but
They're
it was
the-
at 2:30.
We've been,
right?
yeah, we've been in court. Yeah, 2:30. We just have, usually we'll have maybe a couple. But
Oh.
today we only have you. That's
Oh,
it.
Okay.
That's it. And usually the contested ones we get usually are the speeding tickets. And they're the
Oh,
ones you should contest because they're almost always defensible. It's so technical. But,
Yeah.
Insurance, basically you can't because it's one or the other.
Yeah. Oh, no, you're fine.
No, if you can't find it, yeah, the RCW is 46.30.020. And where you would find that for sure. I'm not sure the statute says whether it's moving or non-moving. That usually that's in the, there's a WAC, Washington Administrative Code, section 142, but and that I can't remember. And that would, Sonia, I'm gonna guess that that's probably something that I would have to search for and take an hour to find in if that is true. Read all of this.
Check. Okay,
150, non-moving.
okay. Oh, no, you're fine. So then does that mean, cause the Geico said, cause they asked if I had a court date and I said yes, so they were waiting to dock me for it until it like shows up on their end, but he was saying if I can try to get it, yeah, to a non-traffic or a non, is that what it means by traffic and non-traffic?
That I've never heard of that distinction.
I'm pretty sure, I wish I had the ticket, but I mailed it.
Yeah, anything that we have is related to,
So like on a
automobiles.
ticket, isn't there like the boxes and aren't the options, isn't it like traffic?
traffic, non-traffic. Now, who is this important to? Usually it's important for insurance purposes, so you want it non-moving.
Yeah, so they said if I could get it, even if I don't get the fine reduced, but if I get the ticket itself changed from a traffic to a non-traffic violation, then it won't raise my insurance, but if it's checked off as traffic, then my
Well-
insurance is gonna raise.
Non-traffic means criminal.
Oh.
That was, I'm curious.
Definitely don't want that.
The other option is you can do what they call a deferral. You're allowed to do that once every 7 years with both a moving and then a non-moving violation with one of each every 7 years. So if you want to do a deferral on this, that'll be a way of keeping it off your record altogether. What I
Okay.
do is charge you $150 and dismiss the citation if you don't get another ticket within the next 4 months.
Would you say that's a good,
You can do that. I'll give you that as an option.
do you think that's a good plan? A
Well,
better
it'll keep it off your record altogether.
Okay, yeah, I'll do that. Please.
Okay,
Thank you.
yeah, that'll keep it off your record altogether. Now, the question is. Yeah, Sonia, what we need to do is. Yeah. Yep.
It used to be longer, right?
Well,
'Cause I
that's
think I did
that's
that
court
when I
by
was
court. Some
16.
courts do it a year. Some do
Okay.
it 6 months. That's up to the individual court. I go 4 months.
Oh, okay.
Leave it at 150. And then erase uncheck the committed box. Yeah, the form we can fill out here says deferred finding for a period of blank months. And that's, so. It was so much easier when it was a piece of paper and I could do that, but now everything's on computer
Everything's
and
electronic.
the computer pretty much tells you what to do.
Yeah. I know I went into a Taco Bell or a McDonald's and I was just waiting there wanting to order some food. And then I'm like, she's like, oh no, you order over here and points to these kiosks and I'm like, what?
That's,
Yeah.
Here's one, yeah, I got it. What the? What now?
Yeah, no, you're fine. So you have some people that come earlier than?
Oh, yeah, we have our first docket is, had. Yeah, this is today's docket.
Oh,
There's,
okay.
I think 65 entries on it. Yeah, first docket at 8:15 and then one at 8:30 in custody. So we had some people in jail. So we had to do that remotely.
So do you do the worst ones in the morning?
No, that's, they
Or does it
just, the
just-
worst ones just happen when they happen throughout
Yeah.
the course of the day. So there was,
I know, I was like fretting it and everyone's like, you are minor compared to the other things they have.
oh
to deal
gosh, yeah,
with."
this is, oh, absolutely. Yeah, we had domestic assaults, drunk driving. It's,
Yeah, that's exactly, everyone's like, it's not like you got a DUI.
yeah, oh, yeah. We handled maybe a dozen DUIs today and at various stages.
Oh,
Some non-compliance with the sentence, some first appearance. We had 3 or 4 first appearances.
crazy.
That it is. Is it a new document or? And then I get the reload site. No, see. Okay. Terms of deferral, complete, yeah, deferred performance, that's it.
And then
Complete driving course and submit proof to the courts by 12:15. I don't, can you, let's delete that, okay? Just delete the driving course. No. No requirement. And then uncheck the box. It's $150 and 4 months.
Okay.
4 months, if we'll check your record, if it's clean for 4 months, it'll close.
Awesome, thank
And
you, I
the,
appreciate it.
And the 150, that has to be paid within the sooner you pay that, the better.
Okay, can I pay it now?
You surely
Okay.
can.
To you or, okay.
Nobody trusts me with money. You'll have to go to the counter.
Okay.
I've signed the order to that effect. Ms. Novak, you get a copy of it at the window outside the courtroom
Okay.
to your left. That'll give you, that's and if who's curious about what it's going to be, traffic, non-traffic, moving, non-moving?
Geico,
Oh, your insurance company.
yeah.
Kind of sounds like you have an agent that maybe there's a failure to communicate, but a lot of it's been my experience that some of these insurance agents, they really don't know. They're,
Yeah, well,
They have
even
a
like
book.
some of the questions I was asking with all the different.
options and what you
Yeah,
should do. And
yeah, and then he came back and he's like, well, don't you have insurance on your other vehicles? And I said, yes, through my dad, not on my own.
that
And then-
was, yeah.
And
that's
then he was like, oh, okay, and I was like, that's why I'm asking so many questions, because I don't know.
That was, yeah, that's. You have insurance and you're driving a substitute vehicle, not your own, not your spouse's or your kids or that is covered automatically under certain policies. There's just so many little wrinkles on that.
Right? Yeah.
Better, a lawyer is somebody that can tell you but
Yeah,
that's
I
that's
forget and he gave the analogy, like, I work for insurance and I still don't understand it, so.
yeah.
Good luck trying to understand all of it and it's antics.
Well, the professionals with the state, Department of Licensing, I've said, more than once, you can call them and 10 different times with a question and get 10 answers. It's all different. But good luck to you.